behalf of Tonzip Maritime Ltd and 2Rivers Pte Ltd.
Yes, good morning.
My Lord, good morning. I appear with Mr. Coldrick, with the Appellant owners, and my learned friends, Mr. Shirley and Mr. Hall, appear for the Respondent charterer.
Yes. So, Mr. Vinyl, I can indicate we've read the papers, or certainly enough of the papers, to give us a lively appreciation of the issues. We'll let you take your own course. We need to rise at 4. One of us has an appointment, so we need to rise at 4. We did think that with a following wind, that the appeal shouldn't take more than a day, but because we have to rise at 4, we quite understand if we have to come back tomorrow morning to finish. But we would hope that if we are doing that, we won't still be sitting at 2 minutes to 1.
I'm grateful.
A gentle,
Ever so gentle.
a hint.
Ever so gentle that the 1.5 day listing is really 1.
Well,
I'll do my best.
Maybe 1 and a bit. But yeah. So do take your own course. But as I say, we have read enough of the papers to.
Well, that's helpful, and in particular, if I'm dwelling on a point which there's no point in dwelling on as I go through, please give me another hint, and I can then take that as well. Can I tell you what I'm proposing to do with Mr.
Of course.
Mr. Coldrick? And we are hoping we can manage this by lunchtime. There are 7 points I want to cover. I'm going to begin with an outline to the appeal and the cross appeal. Secondly, I want to say something very briefly about how wide the concept of control is in UK sanctions law. Thirdly, I want to take you to the material available at the time when owners had to decide whether to accept the instruction to lift the cargo, and it may be that some of that I can take quite quickly if you've had a chance to look at it. Fourthly, I want to make a suggestion as to a useful framework for looking at some of the authorities on sanctions, and suggest that it's vitally important to bear in mind 2 sets of distinctions. One is whether a clause or a type of defence is something which arises in the course of performance or only afterwards when somebody's trying to enforce a debt. And the second is to be very clear as to whether one is looking at provisions which deal with the actual state of affairs or somebody's reasonable judgment about the state of affairs. Because if one gets that straight, one can avoid some traps. I'm then going to deal very briefly with the cross-appeal point, because it's not my appeal. And then I will deal with the appeal grounds, which by then I hope I can take quite quickly. I'll deal with perversity in grounds 2 to 7. And then Mr. Emmett will deal with the slightly distinct issue of grounds 8 and 9, which deal with the EU decision. So an overview of our position, the first of the 7 things we wanted to deal with. The judge was right to find, as he did at paragraph 73 and 77 of his judgment, in relation to the construction of the sanctions clause. He said, at 73, it's bundle 8 79, the reference to such risk refers to the reasonable judgment that it will expose the owners to sanctions. That means the claimant does underline not have to show that any of the listed parties would be in breach of sanctions, but that it had reached a judgment that a reasonable ship owner could reasonably have come to in the circumstances that the listed parties were exposed to sanctions, in that they were subject to the risk of sanctions. We say that's exactly right. And we say he therefore asked himself the right question when he set out his analysis. That is, on the facts, did the claimant make an objectively reasonable judgment in that they were subject to the risk of sanctions? Pausing there, he could perhaps have put it in a slightly different way. Was the judgment reached by owners one which a reasonable owner could reach? That's the Falconera formulation, but it amounts to the same thing.
It's contractual discretion. It recognises that the decision is not one for the court as such, but for the contractual decision maker, but within controls of rationality or...
Exactly. Almost the sort of public law test. Now, ultimately, the judge answered that question no. We say he should have answered it yes. And the reason he should have answered it yes has, I think, strictly speaking, two limbs. The first is because owners did, as a matter of fact, form the view that there was a risk, that Mr. Gutseriev continued in de facto control, and they were therefore at risk of sanctions. And B, that was a reasonable view for them to form in the circumstances. I emphasize in passing that the quality of their decision-making process is irrelevant. Because if an objectively reasonable decision were genuinely reached, it would not matter if it was reached by a process of unparalleled perfection or sketchy soundings. And there, obviously, I echo the words of Lady Justice Cockerell in the Ceto shipping case, but I've left out the paper, scissors, stone limb of that, because my learned friend says, well, maybe if it was paper, scissors, stone, it couldn't be a reasonable judgment in the first place. But in any event, the point is that as long as a judgment has been reached, and it's a genuine judgment, the quality of how one gets there is not something for the court to consider. So why was it, in our submission, reasonable to form the view that there was a risk of exposure to sanctions? We say there are 7 factors. And before I describe them, can I just explain a shorthand I will use, which again is drawn from Mrs. Justice Cockerell in Veneshprom Bank, and that's, quote, cosmetic disposal. Nothing to do with lipstick that is surplus to requirements, but by cosmetic disposal I mean taking steps to make it appear you have relinquished control or transferred ownership when in fact you have not, because ownership and or control, at least in a de facto sense, sufficient to meet the sanctions control test, has been retained by you. So the 7 factors are these, and I begin with the heftier ones, and I concede that the ones at the end are way less heavily in the balance. First, the apparent transfer of control of Mr. Gutseriev's ownership was very close in time to the sanctioning of Neftisa. We say a red flag, raising at least a serious possibility that this was a cosmetic disposal. Secondly, the person to whom it was alleged that Mr. Gutseriev had transferred both ownership and control was his brother. Another red flag, raising a serious possibility that this was a cosmetic disposal. Third, there was no evidence as to the terms on which or consideration for which the business had allegedly been transferred. Fourth, there was nothing at all by way of assertion or statement from the ultimate beneficial owner, Mr. Gutseriev, or even from the holding companies as to what had happened. So there's nothing which, in a sense, could come back to bite Mr. Gutseriev at a later stage. Fifthly, those omissions were not remedied by the legal advices provided. Those advices were, and this is not a criticism of them, extremely cagey, replete with caveats, and on their face, not something on which owners could reasonably rely, because they said they shouldn't. If anything, the advices made matters worse, not better, from the point of view of exposure to sanctions risk, in the sense of giving rise to a greater worry about the possibility that this was a cosmetic disposal. And then 6 and 7, these are, I accept, lesser points. 6 is that the ownership of the cargo was disclosed very late, just 2 days before the intended lifting, despite charterers, having known since April of 2021, so April of that year, that they would be asking owners to lift the Neftisa cargo. We know that because we've seen the contract. It's in the bundle at page 101, and it's for a cargo every month, starting in June. And it's a cargo from Neftisa. So they knew, but they didn't disclose that till very shortly before. And the seventh point is that there was a complex and non-transparent ownership structure. But I entirely accept that 7 taken on its own would not take me anywhere. Now, we say that given those factors, there can be only one answer to the question: could an owner reasonably take the view that there was a risk of exposure to sanctions? We said, with the greatest respect to the judge, blindingly obvious that there's only one answer to that question, which is yes, you could take that view. I needn't go so far as to say there could not be an owner who would take a different view, but actually one wonders even about that. But anyway, all I have to demonstrate is that this was a reasonable view to take. So we say that the result was perverse, but we say in any event one can see that the learned judge made errors of law in the dispositive part of his judgment. And I'll take you briefly to that, but I'll obviously come back to it. So on the second issue, not the construction issue, but this issue, the dispositive passages are paragraphs 131 and 132, and they're in your bundle at page 92. He sets out in the heading the correct question in the bold passage above 131. Accept that's the right question to be asking. But he says in the, I think the critical paragraph is 1322. We'll look at all of this later. Whether Mr. Gutseriev did control Neftisa or not is speculation. Well, certainly it was uncertain. It's not evidence of an existing state of affairs. As Olga Ventsina stated, owners have not been able to confirm whether Mr. Gutseriev has de facto control over Neftisa. And Mr. Tay candidly admitted in his evidence that remained the position. Well, that is right. They could not confirm the position, but they were worried about it, and they thought they were exposed to a risk. And he says that this amounted to a non-admission. Now, that picks up some references in the Itasca, which I will obviously go to, and I'm going to submit that, with respect, the learned judge misunderstood what my Lord Justice Foxton was saying in the Itasca in that particular passage, or at least didn't realise that it was directed to a different issue. And then he says, that, in my judgment, is insufficient to amount, brackets 2, an objectively reasonable decision that Mr. Gutseriev had de facto control, and therefore entitled the claimant to rely on the provisions of some. Now, I mean, that is a possible reading. What he says is possibly right, but it's nothing to the point.
Not asking the question that he had
He's asked the right question, but he gives reasons for giving an answer to a different question. And that's the absolute heart of what has gone wrong in this case, in our submission. So that's my first point, the outline of the appeal. Second point, just a short disquisition on control and how widely drawn it is. And for this we need the authorities bundle, but only 3 little bits of it. Can we go to page 3? And these are the Republic of Belarus sanctions regulations of 2019. And at page 3 we have regulation 7, which shows us the meaning of owned or controlled directly or indirectly. And you can see that it says a person who's not an individual is owned or controlled directly or indirectly by another if either of the following 2 conditions is met or both are met. Let me start with the second condition. So subsection 4, The second condition is that it's reasonable, having regard to all the circumstances, to expect that P would, if P chose to, be able in most cases ... Now that's the capable of taking control point, on which perhaps it's fair to say that views have differed amongst the judiciary.
I can't remember if you were chairman of the bar when the Court of Appeal in Mints came out, but it caused some consternation.
It did.
In the London litigation and arbitration markets.
It did, my lord. But on any view, even on the narrower view of that, it's widely drawn. But we shouldn't overlook the first condition. So the first condition, and we could perhaps focus on C, holds the right directly or indirectly to appoint or remove a majority of the board. Subsection 3 tells us to go to Schedule 1 for help for the purpose of interpreting paragraph 2. So if we go to page 17, we get some help. And that says, where a person controls a right, the right is to be treated as held by that person. And not by the person who in fact holds the right unless that person also controls it. And a person, by 11 sub 2, a person controls a right if, by virtue of any arrangement between that person and others, the right is exercised only by that person or in accordance with that person's directions or instructions or with that person's consent or concurrence. And if you were wondering what arrangement means and whether perhaps it is limited to legally binding obligations, you would do well to turn the page to page 18 in the bundle, where we find that by paragraph 12, arrangement includes any scheme, agreement, or understanding, whether or not it is legally enforceable. And so the upshot of that is that if there is a non-legally enforceable understanding between the brothers Gutserief, that the brother will exercise voting rights only with the consent or concurrence of Mikhail, then Mikhail is in control. That's enough. So it's not a high hurdle. That's control under English law, but we have some English law sanctions here, so that's sufficient for my purposes. So my third of 7 sections may take a little bit longer, the material available at the time. Yeah. And I'm going to divide it into the material which my clients procured for themselves, some material which they did not in fact see, and then finally the material they were provided with by charterers. So their own material, if you like. Can we begin with the infospectrum report on Rosneft? That is at 143 in the supplementary bundle.
So that the heading is, this is the material that your clients procured.
The major heading is material available at the time.
Yeah.
And the subheading is stuff we got.
Yeah.
Yes. And you can see they downloaded this on the 11th.
Supplementary bundle page
142.
142, thank you.
This is about Rosneft. You might ask, why did they get a report on Rosneft and not Netvisa? Well, on the 11th of November, which is when this was downloaded, they didn't know who was lifting the cargo, but they'd heard rumours in the markets that it might be a business related to Mr. Gutserief. So this infospectrum report, I take it very quickly, page 144, ultimate beneficial owners, this is just under the bottom of the page, various, although perceived to be largely controlled by Mikhail Gutseriev. At 146, describing the history of Rosneft, publicly quoted company registered in Russia, and at the bottom of that history section, in addition to his interest in Rosneft, Mr. Gutseriev also controls another substantial commercial conglomerate, Safmar Group, ... If we go over the page to 147, recent developments. In its latest annual report, Rosneft disclosed that as at 31st of December 2020, so that's before any sanctions, the person able to control the actions of the company is Mikhail. We note that since this point, Mr. Gutseriev has been placed on the EU sanctions list due to his close relations with and interest in the Belarus economy. We emphasize Rosneft is not sanctioned. However, the event has had some ramifications for the relationship between Mr. Gutseriev and Rosneft, as Mr. Gutseriev is widely reported as having stood down from the board of the company with a likely intention of giving the company the freedom to manoeuvre in the manner to which it is accustomed. So it's saying that there has been a change, and it is likely that the driver of the change is to give the company the freedom to manoeuvre as it has done in the past. And then at page 150, under the heading References, during the course of our inquiries, we approached a number of contacts. Then picking it up 4 lines from the bottom, with regard to the status of Mr. Gutseriev, this source stated his prominence made it difficult to avoid companies where there's a connection with conducting deals in the Russian oil market. Hence, Rosneft's market reputation appears to remain fully intact, although some degree of caution may be discerned until the full implications emerge. And then finally, at 152, the closing paragraph at the top of page 152, we note the EU's decision to impose sanctions on Mr. Gutseriev, emphasise Rosneft not sanctioned. Nevertheless, we detect some distance emerging between Rosneft and Mr. Gutseriev, as he's reportedly stepped down from a direct management role, possibly to limit any impact on Rosneft. Rosneft remains well regarded in principle, blah, blah, blah. However, we would strongly recommend a close monitor is placed on this situation, hence the short review period recommendation. So that's what InfoSpectrum were saying. If we go to page 160, we can see the first of the 2 reports after Neftisa was identified as the cargo owner or party with an interest in the cargo. So 160, you can see the name that has been checked is Dr. Mikhail Gutseriev. It's been created and screened and printed on the 15th of November by Olga Ventsina, who you will have read about in the judgment. We see in the key data that Mr. Gutseriev is a PEP, a politically exposed person. The third line down. And if we go on to 163, the biography, the penultimate sentence at the bottom of 163, Chairman of the Board of Directors of Neftisa, February 2015 onwards. And then the various sanctions are listed. The EU sanctions, that's at page 164. Switzerland sanctions, bottom of 164. And UK sanctions, bottom of 165. And can you go to page 170? About 5 or 6 lines up, there's a hyperlink to commetsant.ru doc 4910175. That's the Commetsant article. My clients didn't press that link. They didn't look at that article, but it was available. It was there, had they wanted to. And then finally, in terms of material, they procured 156 on NEF, which is about Neftisa.
Sorry, page?
156. Again, printed and produced on the 15th of November by Olga Benzina. This time, the name that's searched for is Neftisa. And at 157, biography associated to a sanctioned individual, reported 2021, and it identifies Mr. Mikhail Gutseriev. So that's the screening material of a type which you would expect.
Under the heading biography on page 157, what's the significance of the word reported under biography? Last line reported July 2015 to July 2021. Is that the date the reports occurred, or that's the date he's reported to have been in that position?
I don't know, I'm afraid. He certainly was not sanctioned in July 2015.
Yeah.
He wasn't sanctioned until 2021, or designated till 2021. It may be that since 2015 he's been reported to be the indirect owner and chairman of the board of directors. That's probably the most natural reading, I should think. Yeah. And that certainly seems to fit with everything else. So two things which my clients didn't see at the time but clearly were in existence and might have been available to a notional reasonable owner. At 117, an article from Reuters on the 23rd of June, so just after the EU sanctions, and it reports that Total has asked the commodity pricing agency S&P Global Platts to avoid buying oil from Russian businesses Mikhail Gutseriev as European energy firms seek clarification from the EU after it slapped him with sanctions. Dropping to the third paragraph, Gutseriev is a major owner and founder of Safmar, the management company for Russian oil producers Rosneft and Neftisa, as well as refining companies, ... And then over the page, when they're reporting what various traders have said, second paragraph on 118, third paragraph, Total and other major European oil companies and trading work firms, as well as Safmar Holding, were also consulting lawyers in the EU about the terms of work under the sanctions. It's not clear how and if we may continue to work with companies connected to Gutseriev, so we were advised not to touch these barrels until it is clear. One of the traders told Reuters, and Safmar Holdings had declined to comment.
I'm sorry, Mr. Vinyl, what date did you say this was?
Yes, it's the 23rd of June, and we see that in 117, because it starts Moscow, June 23rd, Reuters. Just under the picture,
yeah.
Really.
Yeah.
You've taken us to this. It's not something that was accessed by your clients at the
Correct.
time. At some point, are we going to come on to the topic of how far material going one way or the other that is not in fact accessed is relevant to the question?
Well, I can tell you actually straight away what we say the position is on that. And first of all, just make clear, I say that if one limits oneself only to material which we had actual access to, it demonstrates the 7 points which I referred to. But I say, lest I should need it, that when one considers whether a view which was formed was a view which at that time a reasonable owner might form, you should not be limited to what the actual owner had. You are permitted to say, well, is this a view a reasonable owner could have formed? And if there's something a reasonable owner could have got hold of, then you can take that into account.
We may come back to that when we come to your process outcome distinction.
And then there is the Commissant article at 154. And that's dated, very small print at the top, 22nd of July 2021. As Commissant learned, businessman Mikhail Gutseriev, who fell under EU sanctions in June, transferred control of his second key oil asset, the Neftisa company, to his brother. At the same time, he remained a minority shareholder. ... According to lawyers, it is not yet clear whether the EU will evaluate the Neftisa deal as an attempt to circumvent sanctions. And then if we go over the page, second paragraph, the companies of Mikhail Gutseriev, after the imposition of sanctions, had problems selling spot oil shipments. At the end of June, Reuters wrote about the reluctance of Total and Glencore to buy cargo. And then it says, in bold, counterparties of companies that were previously controlled by Mikhail Gutseriev will be able to painlessly complete transactions that were concluded before the date of the introduction of the sanctions, explains the head of legal practice of Grace Consulting, Ekaterina all over. But in terms of new set transactions, the situation is ambiguous, according to her. Further cooperation with companies whose shareholders Mikhail Gutseriev left will depend on how the risk management of counterparties interprets the norms of sanctions restrictions. And then in the next paragraph, the main question is whether the transfer / sale of shares in controlled companies will be regarded as actions aimed at circumventing sanctions, the lawyer says. So that was clearly in the public domain at that time, although I accept my clients did not see it. And then the third category of material is what my clients were given by charterers. And the first is the Neftisa letter at 178. And you can see at the head of the page, that is Neftisa in Cyrillic script at the top of the page. It's dated the 16th of November 2021, so I think there's at least a strong inference it was provided for the purposes of the particular dispute over this cargo. It's addressed to Coral Energy. It says, in response to your request, we're informing you that on the basis of information provided by the sole shareholder of Neftisa, as on the current date, Mr. Gutseriev, Mr. Michael Gutseriev, is not the controlling person of Neftisa. He doesn't have the right to control half the shares. He doesn't have the right to appoint the sole executive body. He's not a member of the board of directors. There are no other grounds in the current legislation of the Russian Federation for establishing control over the company by Mikhail Gutseriev. So it's all about the position under Russia.
The 2 points do sort of track Regulation 11, don't they?
They track the face of it, but not perhaps the softer underbelly. Which is the bit that bites, the bit that is likely to bite in a cosmetic disposal. That's the problem. So that's the Neftisa letter, and then we have the materials from HSF, which begins at 192. So this is a Herbert Smith Freehill's note of the 7th of July, so much closer in time to the designation. And this was a note directed to, as one sees on page 192 at paragraph 1.1, whether Mr. Gutseriev can be considered a controlling person of Neftisa for the purposes of the federal law of the Russian Federation. And under paragraph 3, you can see some limitations and assumptions identified. The conclusions are expressly subject to the limitations set out in Schedule 1 and based on the information available in the documents referred to in Schedule 2, and the assumption that they've been told to make that the corporate structure was correct. If you look at Schedule 2, it's at page 198, and it's the Charter of Neftisa, list of holders of securities as at 15th of April 2021, and a representation letter from the sole executive body of Neftisa of the 6th of July. And if we look at Schedule 1, the limitations and assumptions, at 195, it's probably fair to say they're quite widely drawn. The first of paragraph 1.1 is that the note's based on the information provided to us and no responsibility is undertaken to make any further investigation or to update it. Under the assumptions on page 196 at 2.2.8, none of the persons identified in the corporate structure chart act as trustee, commissioner, ... or otherwise for the benefit of or on behalf of or in the interest of any other person. So the critical question, what you might think is the critical question, is expressly assumed to have an answer. No, there's no ongoing control. So on that basis, it is not at all surprising that at page 193, and still at this stage limited to Russian law, the conclusion is, at paragraph 4, that Mr. Gutseriev does not satisfy the ownership or board appointment test or CEO appointment test.
We don't know what the Russian law test is, do we?
Yes, it's set out, actually. I think. It's definitely somewhere. It might appear, and if it doesn't appear, I shall find it.
Do we know if it includes something akin to the what I would call the shadow director test we see in the UK regulations?
Doesn't appear to in any of the formulations we've seen. So,
is it clause 2 has got at least the definition of control from the Russian companies law, JSC law, which actually is ex facie not that different from the two provisions, but doesn't look like, it looks like ordinary Russian company law rather than
I think that's right.
Sanctions related law.
But the critical point is that the assumptions that are made. And the assumptions that are made is that nobody takes instructions from anyone else. So that's the first note. The second is at 180, but that's really a holding document produced by HSF. It's the 17th of November. And what they're saying is they've been asked to deal with UK sanctions and compile a memorandum. And I think that is, unless anyone wants me to go to it, just a holding document. But the document really is at 184.
104.
184.
184. Thank you.
22nd of November 2021, so just before termination. And Herbert Smith say, paragraph 1.1, in addition to our advice of the 12th of July, ... we now provide advice on the equivalent designation of Mr. Gutserieff under UK sanctions. And you can, as at the date of this note, none of the information reviewed for the purposes of the HSF note on control in relation to Mr. Gutserieff's shareholdings, voting rights and ability to appoint board members suggests that Neftisa is owned or controlled by Mr. Gutserieff, or that Said Salim or Saeed are acting on his behalf or at his direction. But 2.2, if on the other hand, Neftisa was owned or controlled by Mr. Gutserieff, then UK financial sanctions would also apply to Neftisa. Well, subject to reading carefully that none of the information reviewed gives that impression, one shows, one couldn't argue with that. That's strictly correct. But if we go to see the basis of this, it's section 5 on 187, assessment of ownership and control, and they set out the UK legislation and guidance. They say it's not exhaustive, and it isn't, but it's a fair summary. And then at 5.4, they say, well, as set out in the HSF note on control, we understand, based on the assumptions specified in the HSF note on control, that Mr. Gutserieff does not. And at 5.5, the information available to us to date asserts that Mr. Said Salim and Mr. Said act independently of Mr. Gutserieff and any other person and do not act on behalf of or at the direction of Mr. Gutserieff. And then 5.6, in circumstances where he does not, as per the information available to us to date, meet the criteria for ownership and control, then, broadly speaking, you're safe to deal with Neftisa. So that's what it's saying. But again, it's only as good as the assumptions it makes, and or perhaps the assertions that they've seen, but which they didn't share, if there are assertions. They say that they undertake no liability to anybody who relies on the advice. So that's the HSF material. The Baker and Mackenzie material, which you might think is even cagier, is at 133, and again provided to us. The Baker and Mackenzie memo is 14th of July 2021, so it's earlier than those HSF ones we've seen. It says just under the heading that the memorandum is for you only, and it's addressed to somebody at Neftisa, and it may not be used by third parties, but it was shared with us. It sets out the facts and applicable law, and there's a helpful executive summary at page 135 at the top of the page. I'll pick it up at the second paragraph. Based on the information we have, Neftisa should not be regarded as a company more than 50% owned by Mr. Mikhail Gutserieff, because his indirect ownership does not exceed 6.75%, And this might be the moment to turn to page 141. To see the structure of the holdings. At the bottom is All Company Neftisa, 100% owned by Dolmer Enterprises in Cyprus. That in turn going up to the right, quarter owned through a series of BVI companies by Tatiana Novitskaya, who we discover from the Baker and McKenzie memo is a long-term employee of businesses associated with Mr. Gutseriev. And then as to 75%, going up the page through Donald Finance Cyprus to Lambency Holdings Cyprus, in which, as of 13th of July 2021, Mr. Mikhail Gutseriev has a 8.8% holding. And Mr. Said Salim, his brother, at the top of the page, through a Cypriot company, has a 90, just short of 90% interest. So it's I've seen more complex structures, but it's not altogether straightforward. But Baker and McKenzie say, and this really is the nub of it, is the third paragraph on page 135. Neftisa should not be regarded as a company controlled by Mr. Mikhail Gutseriev for the purposes of EU sanctions because Mikhail, 1, does not occupy managerial positions, and 2, does not exercise dominant influence over Neftisa as one of Neftisa's shareholders. However, the fact that Mikhail is the brother of the majority shareholder could suggest that Mr. Mikhail Gutseriev exercises de facto control over Neftisa. Should he exercise de facto control, this would suggest a dominant influence and fulfillment of the aforementioned factors. However, we were informed that this is not the case. Well, and then they go on. The fulfillment of the criterion of control must be assessed on a case-by-case basis. The EU competent authorities could come to the conclusion that Mr. Mikhail Gutseriev has control over the voting rights indirectly held by Mr. Said Salam Gutseriev. So Baker and McKenzie are saying, well, on the basis of what we've been told, there isn't this control, but the EU authorities might take a different view, as indeed they might. There's a slightly longer expansion of the control issue at 139 under section 1.4, but I think it's actually perfectly fairly summarised above, but perhaps if you have some time with just that passage at the bottom half of the page on 139.
Under the heading 1.4.
Under the heading 1.4. And if you go to the bottom sentence summarising the above analysis, based in particular on the assumptions stated above, including that Mr. Gutseriev does not have control over the exercise of voting rights, so assuming the very thing we're interested in knowing whether there's a risk that it might be the case, in our opinion, there are valid arguments that Neftisa should not be regarded as a company controlled by Mr. Mikhail Gutseriev. Well, that's fair enough, but none of that would give any comfort to a prudent owner, we say. So we say that those advices do nothing to dispel the possibility that this was merely a cosmetic disposal. The Baker and McKenzie conclusion, perfectly reasonable on its face and on the basis of what they've been asked to assume and what they've been told. But in fact, we would say, it rather suggests that there is a real risk of sanctions breach if this cargo is lifted. They say, well, the EU authorities might take a different view. Finally, I want to show you what the owners were saying at the time, because it clearly demonstrates a genuine belief that there was a risk of sanctions. And so at 179 in, not the authorities bundle, but bundle 2, please.
Sorry, this is, what's the subheading? What we were...
That subheading is what owners were saying at the time.
Is there any dispute that they held that view reasonable or not?
Well, I don't think there is.
One.
I don't think there is, but it's obviously, it is a key plank, but it's not in dispute.
You'd be in trouble without it.
Exactly.
So, sorry, you gave me the page reference again.
Yes, I'll give you, it's 179 and 183. On to point 4 of my 6 points, which is the point which goes to the authorities. There is, of course, ever more widespread use of sanctions, and it gives rise to a myriad of commercial problems, but perhaps 3 in which loosely sanctions-related difficulties might arise for a contracting commercial party. The first is pre-contract. Might entering into a particular contract put me in breach of sanctions, either because of the nature of my counterparty or what I'm being asked to make, like building a drone without being certain where it's going to be used. But those pre-contract issues are non-problematic because nobody's going to force you to enter into a contract. Just should be non-problematic. You take your time, you decide on the risks. Am I prepared to take the risk? Is it reflected in the price? I decide what to do. Secondly, what one might call intra-contract, whilst the contract is on foot. I'm worried that something which I now discover I'm prima facie obliged to do might put me in breach of sanctions. If I can clearly demonstrate that what I'm being asked to do is illegal, then I won't be required to do it. But I may not have complete transparency, may very well not have it. And if the position is obscure or uncertain, unless I have contracted for some contractual protection, I'm in a very uncomfortable position. And that is why performing parties may well want provisions in their contract, which in a sense give them, and I use this very loosely for the time being, but the benefit of the doubt, so that they can play safe and avoid a mode of performance that exposes them to a risk of sanctions. And one can see very good commercial reasons for that kind of clause. And then finally, there is the position, in a sense, post-contract. After the contractual obligations have been performed, but perhaps before payment. So the contractual performance obligations have been satisfied, and all that remains to happen is payment. Can the debtor rely on sanctions to excuse or suspend payment? Now, that we suggest is rather different, because there you've got plenty of time, and the question will tend to be, is it in fact, can I pay or not? You might actually be able to go and ask a court, or you might be able to ask the sanctioning authorities. It's very different to the intra-contract.
But it might be that, contrary to that, that payment is actually time critical. So in some cases it may be there may be time pressure.
If it's an instalment of hire under a time charter party, it will trigger a right to withdrawal if it's due but not paid.
Yes, I accept that. I mean, it's the world doesn't fall into perfect.
Category 3 is your Latasco category, I think, is where we're coming on to.
Of course, yes. Essentially. But the intra-contract cases arise particularly in contracts where the precise nature of performance is unpredictable at the outset. And so, of course, a voyage charter is such a contract, because you'll know whether your ship will be going, but you won't know who the owner of the cargo is. There's a kind of classic case for needing some protection because you're suddenly told to do something you didn't know you were going to have to do, and it brings risk with it. And so the distinctions which I want to draw are, there are two. The first is about clauses, contractual clauses, which operate during the currency of the contract, sort of intra-contract clauses, rather as opposed to after the event clauses.
I wonder if the clauses are ever so defined, or it's merely that one sees cases engaging with those clauses that can arise in those two different scenarios. I mean, the Litasco clause could have arisen in real time, as it happened. That wasn't the nature of the problem that presented it.
Yes, the Litasco clause could, and in fact there wasn't an express clause for the end of the day. Yeah, I accept that. I mean, the point about Litasco is it could have been an in the course of performance clause, but in fact that was hopeless because it was limited to a change in the sanctions, and so in fact the focus was on a common law, if you like, common law defence, a legal defence rather than relying on a contractual clause. But that is the first distinction, at any rate, to think clearly about, particularly when you construe a clause. Is it intended to help in the course of performance?
Well, moving from the general to the particular, a clause that deals with compliance with orders, which are peremptory in nature where you're entitled to give them, such that it is a breach of contract not to comply, and which have to be responded to in real time, are category 2. Whether one can have generally a useful threefold classification of all sanctions-related clauses, I'm not sure, but you can certainly say that if one looks at this particular clause about following orders,
clearly intra-contract rather than ex post facto. Yeah, I mean, I started off with pre-contract. That's just put that to one side. I mean, there's basically, is it an intra-contract clause or is it an at the end of the day clause? Because you don't need pre-contract clauses because you don't have to enter into contract. But this is kind of classically an intra-contract clause. The other distinction, sort of cutting across, is between cases where what is at issue is the party's reasonable judgment about something, and clauses or defences not based on clauses, but based on the common law, where what is important is the actual state of affairs. And that, again, is a very important distinction to bear in mind. Sometimes you're asking about reasonable judgments, sometimes you're asking about whether doing something, in fact, is a breach.
And then I think there's a third level, which is that sometimes you're asking about a reasonable judgment of risk, and sometimes you're asking a reasonable judgment of actual breach, which is not the same as actual breach, but nor is it the same as a judgment of risk.
And there is, in fact, a further distinction one has to be careful with, particularly because of what's said in the Neshprom Bank about reasonable grounds to suspect. Because if that's in the context of a criminal offence, it will be construed in a way which might not be appropriate if it were a more neutrally appearing in a clause in a contract. And of course, the Neshprom Bank is about that issue. So I think one has to be a little bit careful about porting those observations over into a reasonable grounds to suspect contractual clause. The cross appeal, I'll take this very briefly for obvious reasons. We've said something about contra proferentum. I don't think I need to develop any of that. I should simply rest on what we have said. We say this is not a...
It's a rare case, I feel, when it carries the day.
Quite. But of course...
And just to help me, I mean, you won on the contract construction.
Despite the judge saying he was going to do it.
Despite the judge saying that. So it didn't seem to me that was going to be at the heart of the appeal or the cross appeal, Because either the judge's construction was right or wrong, however he got there. You say he was right for the reasons he gave.
Exactly. So I'm not going to say anything about that. Mr. Shirley has a slightly different point, that any limitation to a central right, like charterers' right to instruct owners to lift a cargo, should be clearly expressed. And we accept that's right, it should be clearly expressed. But we say it doesn't mean you strain for an artificially narrow construction. We really don't think these sort of presumptions either way are likely to be terribly helpful. So that's all I want to say about that. You will have seen our emphasis on such risk in clause C. I can take that more fully later. The one point I wanted to make at this stage is just to remind you about the UK regulations that create offences. Could we go in at page 9 of the authorities bundle to regulation 15? Making economic resources available for the benefit of a designated person. So page 9 in the authorities bundle. A person must not make economic resources available to any person for the benefit of a designated person if P knows or has reasonable cause to suspect that P is making the economic resources so available, and that creates an offence. So that means that for an offence to have been committed, two things must have happened. Get this from Vanessa Bank. Two things must have happened. You did, in fact, make economic resources available to for the benefit of a designated person, number one, and you had reasonable cause to suspect.
It's an actus reus and a mens rea.
Exactly, classic actus reus and mens rea. But it is worth, particularly when one comes to think about Mr. Shirley's competing construction of the EPS Sanctions Clause, it's very helpful just to consider the position of an owner who suspects that they will be making economic resources available to any person who is designated. So they have reasonable cause to suspect that. They don't, of course, know whether that's right or not. It may turn out suspicions are wrong. It may turn out their suspicions are right. But if it turns out their suspicions are right, they will have committed an offence by making resources in the face of a reasonable cause to suspect that it's going to a designated person. Now, it seems to us if Mr. Shirley's construction of the clause is right, they wouldn't be able to rely on the clause to decline performance, because they'd have to go much further and say, well, it's likely that there will be a breach. And reasonable cause to suspect doesn't go that far. So that there is, we think, a challenge for the alternative construction, which the judge rejected, which is that it leaves ship owners in the middle ground in a terrible bind. And the much more natural construction of the clause is one which means that in circumstances where they are at risk of contravening this section, they have the right to decline the instruction. And the judge's construction achieves that. So I can go on to my criticisms, therefore, of the judge's decision. So the sixth of the 7 points, so I think I'm about on track, which is a pleasant surprise. Perversity, ground one. Well, in a sense, perversity is always a short point. It has to be, but we say that this is one of those perhaps quite unusual cases where if the judge's correct construction of the clause is fairly applied to the facts, there can be only one outcome, which is that when the owners formed the view, which they clearly did, that lifting the cargo exposed them to a risk of sanctions, that was self-evidently a view that a reasonable owner could form. And that is the nub of the point. I identified the 7 factors at the outset, which we say were in play, and I don't need material which we didn't see to make any of them good. But we say those 7 factors raise a powerful case of a risk of exposure to sanctions. And can I just show you, they post-date the events we're concerned with, but can I just show you some guidance from the authorities? So in the, by which I mean the sanctioning authorities. Can we go in the authorities bundle right to the end to 764? So this is...
So what page?
Yes, 764. Tab 28, if you're fortunate enough to have tabs, which I'm not.
Yep, yep. For once, I am.
So this is a global advisory from HMG issued by the Multilateral Repo Task Force. If you go to 766, you'll see what that is. Shortly following Russia's invasion of Ukraine in February 2022, Australia, Canada, France, Germany, Italy, Japan, the United Kingdom, the United States, and the Commission launched the Russian elites, proxies, and oligarchs task force. So that's what repo is. And then at the bottom of page 766, to underscore the repo task force's commitment to work collaboratively with the private sector and to deny key Russian elites and proxies access to revenue and sensitive goods, the repo task force has identified certain typologies of Russian sanctions evasion tactics and is issuing recommendations to mitigate the risk of exposure.
For typologies, do they mean types?
I expect that they do.
I mean, I appreciate it's a government document drafted by civil servants, so it's going to use flowery language, but I'll read that as types, unless anybody tells me not.
Yes. But like competencies being competences.
Yes.
So types of Russian sanctions evasion, and the first one, this is on 767, is use of family members and close associates to ensure continued access and control. And I can pick it up halfway down the page after the reference to footnote 3 with the word asset transfers on the right-hand side. Asset transfers to family members or close associates sometimes occur in the period immediately leading up to a designation or closely thereafter, which may indicate an attempt to evade sanctions on the part of the sanctioned individual and the party that facilitated the transfer. In addition to being able to exercise control through their proxies, arrangements ostensibly moving control or funds to family members also conveniently allows the designated person to avoid scrutiny from both regulated industries and the competent authorities. And then at 778, in the same bundle,
I see that footnote 4 is an article in Forbes, a guide to all the outrageous mansions and estates owned by sanctioned Russian billionaires.
Yes. And then at tab 29, which starts at 778, this is an extract from an Council of the EU document from July 2024, so it's late, I accept.
Just trying to work out, as it were, am I right? You're going to these documents, perhaps unusually, some might say in the case of government and council documents, for the purpose of establishing a proposition you say is simply a matter of common sense at the relevant time,
Yes.
rather than because the documents in which that common sense appears themselves have any significance as official pronouncements.
Exactly. And I suppose it really goes to this. If owners form a view that something is a bit whiffy, and it becomes established thereafter that the government is telling you to be very careful when those circumstances arise, it becomes very difficult, we would say, to judge the earlier judgment that it was whiffy as being something a reasonable party could not reach. I don't think I put it any further than that, but we'd say it's actually quite, put that way, it's quite a powerful point. And so the EU are saying in July 2024, they set out at 779 criteria to be taken into account, and at paragraph 67, which is in your bundle at 780, the following examples describe circumstances that may qualify as indications that a designated person or entity has control over a non-designated entity. They're not exhaustive, only illustrative guidance. And at C, transfer of shares at a time close to the designation. And at D, use of front persons and new owners closely connected to the designated previous owner, for instance, a family member or former employee or business partner. And can I briefly show you in Beneshprom Bank, which is at 548, and I'll be a bit stuck if you ask me exactly what proposition of law I'm taking you to this for, but I think, nevertheless,
It's for a proposition of fact, isn't it? You're going to it.
well, it's at least to show a view that was taken in a case on very similar facts, we say. So in Beneshprom Bank, tab 23, thank you, page 548.
Yeah.
This was an attempt really to knock out the claimant's funder on the basis that the claimant's funder, well, that there was reasonable cause to suspect that the claimant's funder was owned or controlled by designated persons. And the first issue was whether, in this case, one was concerned with whether they were in fact controlled by a designated person, because it was not enough for the offence to be committed to have reasonable grounds to believe. As we've seen, there's an actus reus and a mens rea. So the court rejected the application on the basis we couldn't demonstrate there was actually coming from a designated person. But it did go on, obiter, to consider whether, in fact, on the facts, there was reasonable cause to suspect that the Russian company was controlled by its former owners. And it was doing that in a criminal context, because, of course, the point being run by the defendants was, well, if they were to take any money from this party, they're taking it from a designated person, and they committed the offence. So at paragraph 54 on page 561, and I take you to it because the judge quoted some of it, Mr. Justice Cockerill, if she there was, sets out some uncontentious relevant law on the subject of the test of reasonable cause to suspect. Just want to emphasise that is in the context of the criminal provision which I showed you earlier. And she included at little 8 a reference to the speculation point in Litasco, I have to say I'm not altogether persuaded that belongs there.
I'm fairly confident it doesn't.
Well, I think it doesn't. And I mean, interestingly, actually, when our judge quoted that passage, he didn't include 8, and it doesn't belong. It's not right. But we can see what the court in Veneshprom Bank said about reasonable grounds to suspect, and pick it up at 82. The argument on reasonable grounds to suspect advanced by reference to a number of strands. Reasonable cause to suspect there was a joint arrangement to the controllers in the past, and various points taken. We can go, I think, to 125 for the conclusion, at page 575. Taking together all the matters which we do consider amount properly to evidence, we are by some margin persuaded that were the test reasonable cause to suspect, it would be met on the facts of this case. This is not a situation where there is one query or area where suspicions arise. It's a case where there are multiple overlapping indications which suggest that the transfer and sale were not arm's length transactions. There's the original joint arrangement. Well, that's background. Primary amongst the points which indicate there's reasonable cause to suspect the joint arrangement is still in place is the unsatisfactory nature of the evidence about the sale price, reporting that we know nothing about the terms of any transfer in our case. The figure given is surprising. The financial documentation adduced fails to provide coherent or robust justification for that figure. We don't have anything at all like that in our case.
I mean, you made the point at the start of your submissions, which I understand, that one must distinguish between the context of judicial determination of something in fact, or here reasonable suspicion, and the owner's reasonable assessment of a risk. But aren't you rather relying upon fact findings in one context here as a prop for the other? And you can see the level of detail into which they were able to go on the material before them. Just wonder how much help we get from a set of different facts being analysed in a very different forensic context.
Well, you don't get enormous help, but it is. I would submit it is helpful. It is persuasive, and in some ways our case is a fortiori the facts in Veneshprom Bank. In Veneshprom Bank, there were written statements from those who said they parted with control, saying so. I mean, we don't have anything.
And from the 81-year-old man who bought the company at a knockdown price despite having exhibited no previous commercial interest in that area and so forth. I mean, every case has its own story.
Exactly. Well, I'm not going to take any further time. I'm not going to take any further time. So we do say, with respect, that the decision is perverse, and you could not reach that conclusion on the basis of the facts. But then one might say, well, why would an experienced Deputy High Court judge reach a perverse conclusion? And in fact, we think that the short answer probably is that he rather lost sight of the question he was answering, and he ended up answering a different question. So I need to go back to the dispositive part of the judgment. And I mean, I stress there's a sense in which I don't, if you're with me on perversity, I don't need to explain why he got it wrong, but if you're against me, I would need specific grounds.
Well, usually with a case decided, as you say, by an experienced judge, and even though sitting as a deputy, a very experienced judge, it's usually helpful to see why the appellant says that judge got it wrong on this occasion. But we understand that perversity, if right, is an answer, but I think it's very useful to look to see why you say that result happened.
Yes. So that is the dispositive part. I probably ought to take you to Litasco, actually, because not all the court will be equally familiar with Litasco. And I think, to take...
I've already noted in the margin on at least one point, ask DF.
Well...
So
shall I leave it? Shall I leave it, but just to tell you in outline what we say about Litasco, rather than taking too much time.
I want at least it might be helpful to the respondent.
Yes.
Because I was having a look back at it, but
yes,
there was evidence from the claimant of no continuing control and a non-admission from the defendant
exactly
that was the case.
Yes.
And a request to go to trial in a summary judgment application on that basis. So I am somewhat surprised to see it has gained traction in any subsequent cases. But there, I suppose I shouldn't.
Yes.
Shouldn't,
well, I mean that's it. I'll take this really quickly. It's a claim for the balance of the purchase price of a consignment of oil. So it is absolutely not an intra-contract arising case. It's after the event. It's when everything's done, performance has been done, and that it's sought to defend against a claim for non-payment. There was some material about force majeure totally irrelevant. There was a contractual defence, which on its face looked a bit like ours, that there was a right to suspend performance if, in the reasonable belief of the seller, performing may result in or risk the seller breaching trade sanctions. That looks a bit like our case, but it was limited to new sanctions introduced since the date of contract, and there weren't any. So it was just a dead point. So that was a case in which the parties, as Lord Justice Foxton put it, had decided in advance when they contracted that they knew what they were going to do, they would take the risk, they would decide whether there was a breach of sanctions, but they wanted to protect themselves against new sanctions. Not our case. Our case is any sanctions. And so, having disposed of the contractual defence, there were at least two substantive defences under the general law. One was the party allegedly indebted saying, I may not, as a matter of general law, pay because it's President Putin, who is designated, who controls Litasco. And that obviously had some support from the editor of comments in Mints, but that was rejected. But that's not our case anyway. And the second defence, not a contractually based defence, but a general law defence, was I'm not able to pay, I cannot lawfully pay, because I do not admit that Mr. Elekperov, who is designated, no longer controls Litasco. Well, that's obviously hopeless. I mean, it's just self-evidently hopeless, just because it's a non-admission, and against an assertion that Mr. Elekperov did not any longer control Litasco. So that's all it is.
But that's where the non-admission point in paragraph 1322 comes.
It's where the non-admission point comes from. It's where speculative comes from.
Yeah.
And in our respectful submission, it's just a different point. Just a different point. So, the grounds I've taken them in turn in the skeleton, and I repeated the grounds in the skeleton. So I think I can take this quite quickly. Ground 2 is in the skeleton above paragraph 18. The bundle, it's I think page 22.
Yeah.
This is the wrong starting point. And we say that in paragraph 132 the judge started in the wrong place, asking whether there was positive evidence that Mr. Gutseriev continued to own or control Neftisa.
Is this really, though, a subset of your point that having identified the correct question on the construction, the judge then asked a different question of was there reasonable grounds for believing the actual position rather than the risk?
It is that point. I think actually it is that point. Yeah. And I've said in the skeleton why the judge adopted that approach is unclear, but it may be he thought that he should follow the Tasco approach, and it's with respect just not right. And ground 3, which is really closely related, is the required judgment was as to risk of sanctions, not as to control in fact. And I think that captures this passage in the middle of subparagraph 2. Whether he starts off, whether he did control Neftisa or not is speculation. Well, that again is picking up language from Litasco, where you said it was pure speculation. But he, in a sense, criticises owners for saying they've not been able to confirm whether Mr. Gutseriev has de facto control. And Mr. Tay, that he couldn't have said whether Neftisa was owned or controlled. And he says that's a non-admission, again picking up the Litasco wording, rather than advancing a positive position. Well, in a sense, it is a non-admission. It's a non-admission as to actual control. They can't say whether there's actual control. But it's perfectly consistent with forming a view that you're exposed to a risk of sanctions. That's the point. And that wouldn't have passed muster in the Tasco, clearly, because it's an after-the-event case and it's a general law case. So that's ground 3. The judge confused what he ought to be looking at, which was a judgment as to risk of sanctions, rather than what the owners were saying about control as a matter of fact.
Yeah.
Ground 4, this is my skeleton at bundle 25. He says at 132, subparagraph 1, where one considers Mr. Tay's evidence in the contemporaneous documents, the foundation on which the claimant's decision was built consisted of the refinitive reports on Mr. Gutseriev and Neftisa. Well, yes, in a sense, they did what all owners do. They go to the commercially available material and they see it, and for them it raised alarm bells. Now, he says, when one examines those reports carefully, there's nothing in them which evidences Mr. Gutseriev's control, direct or indirect, of Neftisa in November 2021. Well, in a sense, that's true. But again, it's just not the point.
Well, it's another way of, you say, demonstrating that the judge was answering the wrong question.
Exactly.
Maybe there are fewer grounds of appeal here than the notice of appeal might suggest.
It takes the criticism seriatim, but in a sense, when one has taken the wrong route, it will have a series of symptoms, and I suppose I'm treating each symptom as a ground of appeal. But so that's the Refinitiv World Check reports. Litasco and Finesse Prombank I've dealt with already. That's the fifth point. I do just want to say something about ground 6, reasonable conclusion, not reasonable process. Obviously I wasn't at the trial, but Mr. Shirley at trial had some very effective cross-examination showing that it might be said that the exact way in which the process went wasn't as smooth as it might have been. So I think he landed some hits in relation to that. And in our submission, you can see that the learned judge seems to have been rather affected by that, and he says right at the end of 4, his subsection 4, it was material which could and should have been taken properly into account. Now, that's a classic public lawyer's criticism based on the nature of the process by which the result is reached. And we respectfully suggest that it's neither here nor there. Doesn't matter.
There is a fair bit of authority touching on this point, much of which I think has not made its way into the 3 authority bundles. I'm not saying it should have, because query how central is this. But obviously Braganza did seek to introduce both the procedural and substantive Wednesbury components into employment law. And then there are a series of commercial court decisions resisting the importation of the procedural element into commercial contractual discretions.
And I think the latest is Vinesh-Brombank, and the closest contextually.
Chaos, Citadel, or Vinesh-Brombank?
Vinesh-Brombank. No, Ceto Shipping. I beg your pardon. Ceto Shipping. The passage we cited. And I'm a little bit. I haven't relied on the paper, scissors, stone limb of that, but leaving that to one side, it would be difficult if you tossed a coin, because it would be difficult then to show that it was a genuinely held belief. But if you've got a genuinely held belief, which we clearly have here, that's not in dispute. Once you're over that hurdle, you don't either have to express your reasons elegantly, nor indeed to have taken into account everything that's relevant, nor indeed not taken into account anything that's irrelevant. And the thought of owners having, as local authorities, get council to write their decisions, to tell them that, we all know that happens in public law cases. You decide something and then you get someone to write it up, so it's kind of bulletproof. There's no time for that. There's no space for that in the commercial world. Decisions have to be taken. If you're so reasonably wrong, you couldn't have got there, okay. But if you contracted for a right like that, nobody's
I think
marking
there's
your
an
homework.
interesting point. I'm not sure, frankly, it arises here, where the contractual decision maker carries out certain inquiries on the basis of that, of which material their conclusion is one reasonably open. And the criticism is, if you'd looked a bit harder, you'd have found material on the basis of which that decision would not have been reasonably open. I don't think anyone's ever really got to the bottom of that. Because unlike public law, withholding relief is not discretionary. You have to give a yes or no answer to the status of exercise of a contractual discretion. But I'm not sure really that is this case.
Well, I can see A, the trickiness in that proposition, and B, the non-necessity of grappling with it in this case. I certainly don't need it. This is my ground 6. And ground 7 criticises the judge for saying that all the material was cumulative, indeed even including the Commissant article, that they all spoke with one voice. That's his subparagraph 4 on bundle page 93. That, with respect, doesn't seem to us to be a fair characterization, because I've already shown that, in fact, the Commissant article and the Baker and Mackenzie memo both identified, both gave what amounted in effect to warnings about sanctions risk. Even the Herbert Smith material was so caveated that it really didn't help either way. So we don't think that's right either. But that brings me to the end, I think, of my submissions. I've not touched on the EU judgment, which Mr. Coldrick's going to deal with. But if there's anything else other than the cross appeal, which I could or should have dealt with more fully, I'll try to do so, but I think I've said what I need to say. May I just look behind me as well?
Of course, please do.
Thank you.
Thank you very much. Yes, Mr. Coulson.
Yes, my lord. So, my lords, there are three issues relating to the EU judgment. First, there's admissibility. That's my learned friends Hollington and Hewthorne point. Secondly, there's the question of the time period to which the EU judgment relates. The learned deputy judge thought that it didn't concern the period after August 2021,
Yeah.
and so didn't relate to the period we're concerned with, November 2021. And we say he was clearly mistaken in that. That's Appeal Ground 8. And thirdly, there's the question of where this goes. If the EU judgment is admissible, and it does relate to the period that we are concerned with, does it have a bearing on whether owner's judgment on the sanctions risk was reasonable? And that's Appeal Ground 9. Now, it might seem logical to take admissibility first, but I'm going to leave it to the end, as I think it's important first to address what the judgment says and why we say it's relevant. And that's because, as I'll come on to, the purpose for which we're seeking to admit the judgment may have a bearing on its admissibility. So I'll begin then with time period. The EU judgment is addressed in a single paragraph of the learned deputy judge's judgment, paragraph 133. That's Core Bundle, tab 4, page 93.
Yeah.
And one can see from that his understanding was that it didn't relate to the period after the 21st of August 2021. But we say that it's clear from the EU judgment itself that it related to the period up to at least the 24th of February 2022. The judgment is in the supplementary bundle, tab 8, page 222. And one can see there in paragraph 1.
Supplementary bundle,
Yes, my lord.
tab 8.
Page 222. So it's a judgment of the EU General Court, so the Court of First Instance as was. And one can see in paragraph 1, in the top of the right column, by his action, the applicant, Mr. Gutseriev, seeks annulment of, and then there's two pairs of a decision and a regulation. The first of the 21st of June 2021, which first imposed sanctions on him, and secondly a pair, another decision, another regulation of the 24th of February 2022, which continued the sanctions. So the June 21 ones were labelled the initial acts. The February 22 ones were labelled the maintaining acts, and everything together was labelled the contested acts. And if we pick it up on page 229,
Yeah.
and one can see in the right column, paragraph 67, that Mr. Gutseriev referred to Neftisa operating under the Safmar brand and claimed to have transferred his shares to his brother on the 10th of June 2021. So it's just a small note there. So the date in paragraph 133 of the judgment below is incorrect. Actually, it was the 10th of June. He was saying he transferred it to his brother. So slightly less than 2 weeks before the initial acts, I think 11 days. We saw it was the 21st of June was the sanctions imposed, and he's saying he did the transfer on the 10th of June. Moving on to page 231, paragraph 85. There is a reference to a document taken from Safmar's website indicating that Mr. Gutseriev is the founder, principal owner and chairman of the board of directors of Safmar and responsible for the strategic direction of the group's companies. And if one turns next onto the next page, 232, paragraph 91, as regards Safmar's activities in the oil sector referred to in the contested acts, it should be noted at the outset that it's common ground between the parties that these are the activities of that part of the Safmar group which is active in the production and refining of Russian oil, namely the companies Rosneft and Neftisa. And then in paragraph 93, top of the right column, there's a reference to organizational charts provided to the EU courts showing that, until the 10th of June, Mr. Gutseriev held almost all of Neftisa's shares, but after the alleged transfers, he now owns only 10%. I note in passing that that's not consistent with what Herbert Smith and Baker McKenzie were told. They were told that Mr. Gutseriev held indirectly 6.75%. I don't think we need to go to it. Indeed, I think my learned friend, Mr. Vinyl, already went to a passage in Baker McKenzie. But the references are supplementary bundle, page 134 for Baker and McKenzie, and 199 for Herbert Smith. Moving on here, paragraph 95 in the right column. Please, could you? I ask you just to have a look at that. And then paragraph 97, please, in the bottom right-hand corner and over the page.
Yeah.
Particularly the part over the page towards the end. Although he became a minority shareholder in certain companies holding Rosneft and Neftisa, he's not relinquished any financial gain as he may make therefrom, and secondly, remained involved in the management of and even control those companies. And then lastly in this judgment on, if we move on to page 237, please, please could you read paragraphs 142 and 143? So, what the court is saying to Mr. Gutseriev in these paragraphs is, you're relying on the share transfer, but as you accept, Neftisa is part of the Safmar group, and you're the chairman of Safmar's board. You remained involved in the management of Neftisa, and indeed you control it. And to adopt the phrase that found favour in this court, in the Minsk case, you still call the shots. And that is relating to the period at least up to the time of the maintaining acts, so February of 2022. And that point is confirmed by the ECJ on appeal. If I could quickly show you that, same bundle, page 257. Paragraph 64. In paragraph 143 of the judgment under appeal, so that's the paragraph we've just read, the General Court recalled that it was established that when both the initial and the maintaining acts were adopted, the appellant remained a shareholder in the companies including Neftisa, and that those companies were owned by the Safmar Group, which is a Russian multi-sector conglomerate, of which the appellant is the founder, principal shareholder, and chair of the board of directors. And lastly, the first sentence in 65, it follows that the factual premise on which the appellant's argument, that was Mr. Gutseriev's argument, is based, to the effect that the council relied on facts which took place before the adoption of the acts in issue, the acts in issue being both sets of acts, including the February 2022 ones, and which it ended on that date, is incorrect. Now, Mr. Hockhauser KC got the 21st of August date from Mr. Emilianu's witness statement. That's in the supplementary bundle at tab 5. And if we pick it up at page 68, paragraph 14. So Mr. Emilianu explains that copies of Safmar's English language web homepage, as at certain dates.
Now, that great legal resource, the Internet Archive.
Yes, so it enabled one to sort of go back in time and do a Google search as at a date in the past. So the homepage, as at a date just after the sanctions were imposed, so 24th of June, was found on this archive site. And so Mr. Emilianu quotes from that in paragraph 15. And then in paragraph 16, which is the paragraph of this statement that's referred to in paragraph 133 of Mr. Hockhauser's KC's judgment, we see that on the 21st of August 2021, the website was under construction.
Sorry, which paragraph?
So in paragraph
Of the state, we're looking at. You said we were looking at the statement.
In paragraph 16 of the statement,
Yeah.
there's a reference to the 21st of August 2021, the site under construction. And that is that seems to be the point that the learned deputy judge was making. So he seems to have said in paragraph 133 of the judgment, well, the EU judgment doesn't relate to the period after the 21st of August 2021, because Mr. Emilianu has looked at these archive copies of the website, and the website was sort of taken down. It was just under construction from that date. And we say that, well, first and foremost, one can see from the judgment itself that it related to the period up to at least the 24th of February, when the maintaining acts were put in place. And really, all that's being said here by Mr. Emilianu is that there's this particular sort of archive website that had copies of Safmar's English language web homepage as at certain dates, and it said site under construction. But we just don't know the dates of the documents on which the EU authorities based their conclusions, whether the information was on an English web homepage or some other document in Russian or in English on Safmar's website, or the dates on which all or part of Safmar's website were under construction or had substantive content. The claimant's solicitors asked the EU authorities for copies of the documents referred to in the judgment. They were rebuffed on grounds that the disclosure would undermine public interest as regards international relations, and one can see that in paragraph 11 of Mr. Emilianu's statement on page 68. But the point for present purposes is simply that, as we've seen from the judgments themselves, the learned deputy judge erred in thinking that the EU judgments did not relate to the period after August 2021. They clearly did.
But that document that they rely upon, they give a reference number to it, I can't remember, in paragraph 80 or whatever, is the answer we don't know the date on which that was in circulation on the website?
Yes, we just don't know. The claimant solicitors, Victor O'Brien, wrote the EU authorities asking for copies of the judgment. They were refused, but informed of an appeal process. The appeal process was went through, and they set out as best they could reasons why it was in the public interest, so to speak, for the documents to be made available. But they were again rebuffed by a decision letter. In those circumstances, we just don't have that. But the point really here is quite a narrow one. It's just in paragraph 133 of the judgment, the learned deputy judge appeared to say that the EU judgment doesn't relate to the period we're interested in.
I just wonder if you might not have been getting close to something there, though, because there are limits to the rule in Hollington and Hewthorne. If a judgment records a meeting took place or a document said this, you can rely upon the judgment as evidence that that document exists. That's not in breach of the rule of Hollington and Hewthorne. It's a secondary source of evidence of the existence of a document of that date. If the EU judgment, if it had been possible to rely upon that website document as a document produced after the date of notional sale, continuing to proclaim the original owner's ownership, that could be relied upon. Query what relevance it has to the contractual discretion, but as evidence of that fact. If you can't actually tell from the EU judgment the date in which that document appears, that route round Hollington and Hewthorne, I think, isn't available, because you simply don't know what evidential significance to attach to that website statement, given that you don't know when it was up.
Well, I suppose the best that I could say is that it's a difficult situation where every effort has been taken to find this judgment. And the question, I suppose, would be, can one infer anything about the date of the document? And it would seem to make sense that the document related to a later period, because of the paragraphs that I've showed you, where they were saying that at the time of all of these acts, so the maintaining acts as well, February 2022, you remained in control of SAFBAR. So if we're in these not terribly, it's not great not to have the document, but every effort is made to obtain it. If it does become crucial, I said say there are other reasons why it's not, but if it really was crucial, I suppose I would make the submission that it's reasonable to infer from all the circumstances that the document must have related to a later period, but because the court was relying on it in support of its conclusion that control continued up to the time of the maintaining acts in February 2022. If I turn next to whether the EU judgment is of significance, we say that on any common sense view, it bears on the reasonableness of the owner's judgment. It may be helpful here to disaggregate two aspects of the argument that the EU judgment is of no significance, or could only be of significance as evidence that Mr. Gutseriev retained control, a substantive aspect and a timing aspect. As regards the substantive aspect, consider a hypothetical scenario in which the EU judgment had come out before the owners had to make their judgment about exposure to sanctions. It would be absurd to say that the EU judgment was a factor of no significance. No one would think that. The fact that the EU authorities considered that Mr. Gutseriev continued to control Neftisa would obviously be a highly relevant consideration to any reasonable business person.
That's assuming they know of it.
is it the case that the only significance of the EU judgment would be that it lent weight to the view that Mr. Gutseriev still retained control of Neftisa? No, that would be an odd way to look at it. What's going to matter first and foremost to a commercial person is that this is the view of the EU sanctions authorities. A commercial man would have no interest in going through the court's reasoning and considering the weight that the judgment lends to the reasonableness of the view that in fact control still rests with Mr. Gutseriev. They're going to say the EU authorities' view is that Neftisa is controlled by Gutseriev. I'm not touching this business with a barge pole. Now, what about the timing aspect? Is the position fundamentally different because the EU judgment postdates the owner's decision on sanctions risk? And I say it isn't. If the issue is as to whether I reasonably judged something to be a trip hazard, the fact that someone had tripped over it the week before is obviously relevant, but the fact that someone tripped over it the week after is relevant too. And again, the EU's judgment, its relevance, is not merely that it lends weight to the view that Mr. Gutseriev in fact controlled Neftisa. It is that is the view that the EU authorities in fact took. In assessing a sanctions risk, one will need to consider how the sanctions authorities may view a matter, bearing in mind whether the circumstances of any supposed divestment of ownership and control are suspicious, the reliability and completeness or lack thereof of the information that is currently available, and the risk that further relevant information may come to light. On any common sense view, the EU judgment vindicates the owner's decision not to carry the Neftisa cargo. It shows that decision to have been eminently reasonable and sensible. Insofar as the EU sanctions authorities were concerned, Mr. Gutseriev still controlled Neftisa, and as such, carrying Neftisa cargo would contravene EU sanctions law. I say that leaving the EU judgment wholly out of the picture when assessing the reasonableness of owner's judgment would be a victory for a strange sort of legal formalism, at odds with the expectations and ordinary ways of thinking of reasonable commercial people. Owners rejected the Neftisa cargo because of the danger that Neftisa was controlled by a sanctioned oligarch, and as such that entering into bill of lading contracts of carriage with Neftisa and carrying Neftisa's cargo would breach UK and EU sanction laws. And the fact that the EU sanctions authorities and the EU courts subsequently took the view that Neftisa was still controlled by Mr. Gutseriev would be regarded by any ordinary person as showing that the owner's decision was not just reasonable, but right. The court should, I submit, look at the matter no differently. That takes me on to admissibility. There is a rule of evidence, the rule in Hollington and Hewthorne, to the effect that a judgment in proceedings between other parties is inadmissible as evidence of the truth of the facts found in the judgment. The rule was recently confirmed by the Supreme Court in Evans and Barclays Bank, which held that the rule is based on a principle of fairness. I think I should show you, Your Lordships, that. It's Authorities Bundle, tab 28, page 75. Let me just... So, I think I had a wrong reference. I do apologise. Tab 27, page 719.
Thank you very much.
and one can see here that this was a decision in the competition law context. And just to show you briefly where the Hollington and Hewthorne point arose, one can see on 719 in the head note, just that G, in relation to the strength of the claim, the tribunal held that the proposed class representative had not articulated a viable case on causation. And then over the page, around B, the fourth and Roman 4, fourth point held by the Court of Appeal, a European Commission decision on separate infringement, on a separate infringement, but involving more or less identical facts, provided strong support for the proposed class representative's claim on causation and was admissible. So it certainly was very far from the central point of the Supreme Court, but this issue arose as to whether the Court of Appeal was right to permit reliance on factual matters referred to in this European Commission judgment in different cartel proceedings. And then one can see, taking it up on 755, in the middle of the page, or about a third of the way down, issue 4 then was, did the Court of Appeal err in its use of the Sterling Lads ordinary decision? And that was the sort of label given to this EU Commission competition decision. And then towards the bottom of the page, there's a subheading, admissibility. And the court said that it's a general rule of the common law that findings made by another decision maker are not admissible as evidence of the facts found. This is the rule is often referred to as the rule in Hollington and Hewthorne, where the Court of Appeal held that the defendant's conviction for careless driving was inadmissible in a subsequent civil claim for damages as evidence the defendant was negligent. And there's reference then to Rogers and Hoyle, where the Court of Appeal explained that the rule is founded on a principle of fairness, and that principle requires that a tribunal responsible for finding facts should base its findings on its own evaluation of the evidence and not the evaluation of someone else who's not the relevant decision maker. As a broad statement of the principles, we entirely, of course, accept all of that, but one does need to be careful about the ambit of the rule, of what it does and doesn't exclude. Obviously, it doesn't exclude judgments for all purposes. So, a very basic example was that obviously the official publication of a judgment or a report of a judgment will be evidence of what the court actually decided. The rule only means that, subject to exceptions, which I'll come on to, it is not evidence that the facts found in the judgment are true. Now, I have 4 points on why the Hollington rule does not bite here. Happily, they're quite short. First, we rely on the EU judgment, not for the purpose of seeking to prove that Mr. Gutsuriev did own Neftisa, but rather for the purpose of seeking to show that owners reached a reasonable judgment about the presence of a sanctions risk. We say that the Hollington rule does not preclude the admission of the EU judgment for such a purpose. My learned friend, Mr. Shirley, can point to no case where evidence was shut out on the Hollington basis, where the judgment that was sought to be deployed merely as evidence that a reasonable judgment was made about the risk of breaching a law. Secondly, the use of the evidence for this purpose is consistent with fairness, which is what underlies the Hollington rule. That, I respectfully submit, is self-evident. If the issue is whether one could reasonably judge that the relevant authorities of a country or a supranational body would or might take a certain view of a matter, it would be manifestly unfair and unjust to shut out evidence that they did view the matter in that way. Moreover, extending the Hollington rule to cases such as this would be impractical and unworkable, and so risk unfairness for that reason too. Litigants may well not be in a position, at least without expending large sums disproportionate to the sums in issue, to reconstitute the evidence available to the relevant authority. It would be a costly farce to force litigants to try to litigate the matter wholly anew, so as to assess whether one could reasonably judge that the authorities would or might view a matter in a certain way, when we know that they did view the matter in that way. And where evidence that was available to the other court is not available to the present court, despite reasonable efforts to obtain it, that is a further fairness consideration weighing in favour of its admission, at least in a reasonable judgment case such as this. So that's fairness. Moving on to my third point on admissibility, there is a recognised exception to the Hollington rule in the case of judgments concerning, as it's put in Phipson, public or general rights. There are several old cases in the bundle on that: Petrie and Nuttall, Neil and the Duke of Devonshire, the Crown against Lordsmere, the Crown against St Pancras, as well as extracts from Phipson and Spencer Bauer.
And sorry, those were authorities for what exception to the general rule?
There's an exception in relation to public or general rights, and I'll show your lordship that in a moment.
Okay.
Now,
Public or general rights?
yes.
Yeah.
Now, with an eye on the clock, what I propose to do is just to go to my learned friend's skeleton on this, which I think will suffice for the point that I wish to make. And that's in the core bundle at tab 2. On page 58, please.
Mm-hmm.
And one can see there under the heading Public and General Rights, reference to what is said in Phipson, and then in paragraph 70, reference to Petrie and Nuttall, which concerned a right of way. And a judgment in an earlier case addressing the existence of the right of way was held to be admissible. And in paragraph 71, the Neil case, in which the Cavendishes successfully sought to enforce their fishing rights to the exclusion of the general public over that glorious salmon fishing river, the Blackwater, near their castle at Lismore, in my home. The point for our purposes is that in Neil, a previous judgment was admitted for the purpose of showing that the general public enjoyed no right to fish on that stretch of the Blackwater. Now, I say that the principle that underlies these so-called public and general rights cases is that a judgment may be adduced as evidence that the public are or are not lawfully entitled to carry out some act, to lawfully pass this way, to fish lawfully on this stretch of river, or in this case, to lawfully do business with Neftisa. Indeed, at a high level of abstraction, one of the purposes of reports of decisions in previous cases is to assist in providing guidance to the public at large as to what they may or may not lawfully do. It would be a Pyrrhic victory of legal formalism to say that where an issue arises as to whether something may lawfully be done, in every case, the issue must be litigated entirely anew without any regard to any previous judgment bearing on the question.
Well, if it's an issue of law, the doctrine of precedent will take care of that.
Yes, my lord, but we do say that the exception, the principle underlying the right-of-way fishing rights cases etc., is this sort of public and general rights aspect, and that they should at least have some weight, and one should not be left in a position where one is saying that, well, I was reasonably entitled to take a view that this was unlawful or risked being unlawful. One should be entitled, at least in such a case, to refer to judgments on that. And so, just to give one example, issue arises as to whether certain goods may be lawfully imported into a foreign country. The issue turns on whether they're regarded in that country as dangerous. I do say it would be strange indeed if a judgment of a court of record of that country, upheld on appeal, holding that such goods are dangerous, could not be put forward at least as evidence that importation of such goods would indeed be unlawful.
Well, you'd serve a notice under section, whatever it is, 2 of the Civil Evidence Act 1972 that would make the foreign judgment prima facie evidence on a matter of foreign law, wouldn't you?
Yes, but say if the finding in relation to dangerous was not a legal finding, it was simply it was a finding of fact. In those circumstances, I say that still it would be very odd indeed if one could not say that, well, the issue for us is, was I, for example, entitled reasonably to take the view that I don't have to carry these goods because they're regarded as dangerous. And here you have judgments in this foreign country holding that they're dangerous. And to say that, well, no, you can have no regard to that, you must litigate the matter entirely anew and have expert evidence of how these goods tend to be regarded in this country. I just submit is unreal. And I say that may be contrasted with a case where a judgment is thought to be deployed as evidence, for example, that someone attended a meeting, or that someone's negligence had caused a car accident, or as in Evans and Barclays Bank, certain cartel behaviour by banks led to certain losses. I say that such cases are very different cases, not concerning whether a reasonable judgment was made, as to whether some act could lawfully be done.
This goes further, I think, than you need, doesn't it? Because I thought you were not relying on the judgment as evidence of the truth of the finding made in it, but on the basis that if the relevant tribunal reached the conclusion that Mr. I'm going to call him G for the present purposes, was in control still in 2022, then it was reasonable for you to reach that conclusion as well. You're not relying on the truth, are you, for that purpose?
No. So I think, strictly speaking, this is the third of four points on it. So I would say that we don't need to rely on an exception. But if I'm wrong in that, for the reasons I've just put forward, I'd say that we would fall into this public and general rights exception.
I mean, these would be fairly deep waters, possibly even deeper than the tidal river of the Blackwater in terms of the overall significance of this argument. I wonder how central this formulation is.
We certainly don't say that it is central, and it would only arise. The EU judgment really wouldn't arise at all if one could already say that, even leaving aside the EU judgment, it's clear that a reasonable ship owner could take the view here that there was a sanctions exposure, that there was a risk of contravening sanctions. But beyond that, the primary point is that, well, it's just a different purpose. We're not seeking to admit it for the truth, as to say that this is supporting your lordship's point. But that if my learned friend Mr. Shirley persuades you that no, really that is what we're trying to do, which I think is what he's going to submit as I understand it, I say there is this exception But I won't say any more on that exception. My last point, my lords, is a very short one, and which really is the point that the court has just raised, and that is your lordships already have the point that I say that it's wrong to suppose that the significance of the EU judgment is only as evidence of the facts, that the facts found in the judgment are true, and we say that it's relevant also simply as evidence of the position that the EU authorities and courts in fact took about Mr. Kutserliev's continuing control of Neftisa, and as I have addressed, that is of itself of significance in the assessment of the reasonableness of the owner's submission.
I just wonder whether this is really relying on his evidence, or whether you're saying this is a very good sense check of the position.
Yes. Well, I think we are saying it's a sense check, and we're also saying that we'll, by any sort of common sense look at this, it really is of significance that the EU ultimately found that he still controlled Neftisa, certainly from a commercial perspective. I think any commercial person would regard that as a vindication of the decision. So those I submit are the two ways of looking at it: a sense check, or indeed one can go further and see it in a sort of common sense way as vindication of the decision. So those are my submissions, my lord.
No, thank you very much, Mr. Coldrick. Thank you. Yes. Mr. Shirley, the appellants, having done brilliantly with the hint dropped at the start of the hearing, over to you.
Thank you, my lord. My plan is to deal first with the construction issue, so the clause, then the owner's appeal on reasonable judgment, and then the EU issues at the end. So a brief overview of construction. We're going to start by looking at the clause. I think we won't now need to deal with why the burden is on the owners in respect to ambiguities, because it appears to be, as I anticipated, essentially common ground that the starting point is that there's a key right for the charterers.
I note that it is common ground, and perhaps that's all that needs to be said.
Yes.
It's not immediately intuitively obvious to me that Gilbert Nash is engaged, but no one arguing that it is not. I think you're entitled to conduct your submissions on that basis.
Thank you. Then we'll look at is prohibited and will expose, and the cases that I say are the key to understanding how this clause operates. And we'll also look at such risk and the surplusage argument. Then the text elsewhere in the charterparty, which gives a clue as to the interpretation of the EPS Sanctions Clause. And lastly, at commercial purpose considerations. While I remember, it might be useful before the lunchtime adjournment if your lordships are able to indicate any topics that they do or do not want me to focus on in the afternoon. That might help with the speed of getting through the material. Your lordships have heard from the appellants on a lot of the topics. So if there are topics that I should focus on this afternoon, it might be helpful for me to finalise the preparation of that. If there's an indication, if not, I'll take it as per my plan. So the sanctions clause is it's in both the core and the supplementary bundle. So are your lordships all working from the same set of the contractual clauses?
Well, I've looked at it in the call, so...
Okay, so core, it's tab 19, page 227. And the owners are not obliged to comply with orders that in the reasonable judgment of the owners is prohibited by sanctions or will expose the owners or a series of other entities to sanctions. That's the main part we're going to start off by looking at. So the judge was with us on the construction of the first limb, is prohibited. Paragraph 72 of his judgment, he agreed that meant that the owners had to reasonably judge that there would be a breach of sanctions in order to refuse to comply based on is prohibited. But he said that will expose to sanctions was wider and did not require us to establish that there was a breach. And we say that this approach was wrong and out of line with a series of decisions of Mr. Justice Tier, which we'll look at, in the two decisions in the Triton Lark and one in Mamancache. Before we look at them, a couple of words about reasonable judgment. So the reasonable judgment aspect of the clause means that this is not an unforgiving clause. So it might be that I say that will expose is stricter than the judge permitted, or the appellants say, but it's not an unforgiving clause because it includes the reasonable judgment provision. So it is, on any view, a workable clause. The appellants have complained that my construction is not a workable, practical construction. The thing that makes it a workable, practical construction, apart from anything else, is the reasonable judgment requirement. You might have a clause which simply says you don't have to comply if performance would be illegal or prohibited or would be a breach. But this clause says that you're entitled to make a reasonable judgment as to that state of affairs. So we don't accept the appellant's assertions that the clause is unworkable. In fact, it's forgiving because it's got the reasonable judgment provision in it. So I'm going to come back to reasonable judgment when I look at the commercial purposes. Is prohibited, this is, the judge was with us on this, requires owners to judge that performance would have been unlawful. So it's a simple factual inquiry. Did the owners judge that performance would be unlawful? And the answer to that will turn on what was said and done on the facts of a particular case. And their inquiry is similar to the one that they would have carried out if they had a clause saying that they didn't have to perform if performance would be unlawful. Except here, they're entitled to make a reasonable judgment as to it being unlawful. Will expose to sanctions. Conscious of the time, the authority I want to turn up is the Triton Lark in tab 12 of the authorities.
Well, before we look at a case on another clause, I mean, I'm always very sympathetic to Lord Legate's view that I never derived much assistance from other cases, other clauses in other cases. What in short do you say will expose means?
Well, what we say is that will expose means or requires that the proposed performance would involve a breach of the sanctions laws by the owners or one of the other entities listed in subclause C. And it's the interpretation of will expose adopted by Mr. Justice Tier in Mamancache.
Let's not worry about Mr. Justice Tier in another case. This has got to be doing something different to is prohibited by sanctions.
Yes,
It's got to be something else.
yes. It's,
Proposed performance in breach of sanctions law doesn't sound different.
the two parts of the clause, is prohibited and will expose to sanctions, approach the same issue from two different directions. So it might be, it's a theoretical possibility, it might be that the performance itself cannot be said to be prohibited, so that it is not, it would not be a breach of the sanctions law for owners to perform, but that it would involve one of the other listed entities in the second part of the clause in a breach of sanctions. So both parts of the clause, is prohibited and will expose, have got a useful work to do independently. And in fact, the surplusage argument, which I was going to come on to deal with later on, actually is in our favour, because on the appellant's construction of the clause, the second part of it, will expose, would obliterate the first part, it seems to us. Would render the first part is prohibited OTOs.
Just looking at the clause, there are three subparts, all of which use the concept prohibited in contradistinction to will expose. A is a provision protecting the owners, and it's prohibited or restricted in contradiction to expose. B is a provision promised by the owners protecting the charterers, which rather made me wonder whether one should be conceding this is a clause that exists for the benefit of one party only, but there we are. Again, prohibited or restricted and will not expose. Now, do you accept that the word expose bears the same meaning in each of those three subclauses?
Well, yes, I think we do. And I was going to come on to this, but part of the importance of that is that we do not see the reference to, any reference to risk in the other parts of the subclause. So that the part of subclause C, which the judge regarded as being the key, which gave him the basis for saying that this clause, but the starting point was, it was cutting away from a primary right that the charterers had. The key to why it did that was such risk, but we say such risk can't possibly bear the weight that the judge put on it, and one of the clues to that is that there's no reference to risk in subclauses A or B.
Just on that, if one looks at C, you'll know in unsafe port, you've got a primary obligation of charterers at the port to which a vessel ordered must be prospectively safe when the order is given. And you have a secondary obligation which arises when a port becomes unsafe after the primary order has been given. And isn't C divided into two parts, the first dealing with the order when given, and the second part dealing with the position where the problem arises in relation to a voyage the vessel is performing, i.e. the order has already been given and acted upon, and the owner is being entitled to refuse further performance, i.e. of an existing order, and the charter is being obliged to provide alternative orders. So I think C is in common with a sort of fairly standard obligations in orders in voyage and time charters, addressing two different temporal points, isn't it?
Well, it might be, but I'm not sure if that takes away from the point I'm making about the use of expose in the different parts of the clause, the EPS Sanctions Clause as a whole, in that the reference to the exposure to there's a reference to exposure in A, there's a reference to exposure in B, but none of them is drafted in terms of exposure to a risk. the judge said, or recognised that you didn't have that reference to a risk in the main part of subclause C that we're dealing with either, but he said that in the following words, he could use such risk to, as effectively a tiebreaker, to say, well, in this clause, exposed must mean exposed to a risk rather than exposed to a thing, exposed to sanctions in the sense that there was a breach which exposed the owners to sanctions, which is the Mamancache reading of these clauses.
The point cuts both ways, though, doesn't it? Because if the judge was entitled to use the second sentence in second part of subclause C in construing the phrase exposed in the first half, assuming he was entitled to do that, then that's a reason, assuming that the phrase, as you accept, will not expose means the same in all three subclauses, it would have the same meaning A and B. Why is that not? Why can't you reason backwards in that way to what's meant in A and B, just because the word risk isn't also there?
Well, then I would say it's putting far too much weight on these words such risk in subclause C. But to say that all the way down at the end of subclause C, the words such risk have a transformative effect on the proper construction of expose everywhere it arises in the EPS Sanctions Clause would be an even more surprising contention.
But if I'm right that C uniquely in the clause, but in a very common way in charter parties, is addressing a position at two different points in time, when the order is first given and when a state of affairs arises in the course of its performance. The fact that it is basically transposing the two requirements when the order is given into that later position by calling them such risk is quite informative, isn't it?
We would say not. If clear words are required to take away the key right that the charterers start off with, it would be most surprising to find that they simply aren't clear words, because a reference back to something that has previously been identified is not where you would look to find clear words to tell you what that thing that's been defined is. Indeed, to tell you something very crucial about that thing. And there's a further point on this, which is that such risk also must be read as applying to is prohibited. I mean, if you remove the part of this clause about will expose altogether, the clause reads through as is prohibited in the event that such risk arises, and we say that's perfectly consistent with our construction, whereby the words such risk they're not important words in the clause for determining the meaning of will expose. They simply are a way of referring to what has previously been defined, but not as referring to it in a way that radically changes it. So if you're looking for clear words to expand the permission not to comply from prohibited orders to orders that are not prohibited, you'd need something a lot clearer than a sentence, words that almost throwaway words towards the end of the last part of the EPS Sanctions Clause, which don't really make sense if you ascribe some significance to them in terms of expanding the clause to risk, because they ought to follow from is prohibited as well. So whatever such risk is, it includes the is prohibited. And we know that, as the judge found, those words require a reasonable judgment of a breach.
All right, well, is that a convenient moment? We'll come back at 2.
Yes, my lord.
Court rise if able.